Yes, Mr.
With only
Dr.
one
Shah, thank you.
suggestion, if Lord should also have a watch behind the back so that the advocate will also know how much time he has taken. Otherwise, your lordship are able to see it there. We need a watch there as well. We can't see behind how much time is taken.
Incidentally, I don't know how mobile numbers travel. I get so many WhatsApp messages from people I don't necessarily know. One of the things, suggestions was, why do so many lawyers have to stand behind the arguing counsel? Because they said, is the arguing counsel not disturbed by so many lawyers standing right behind them? So that's something which, of course, is a matter of a voluntary compliance by the lawyers to let the space be a little open for those who are arguing. And of course, those who are assistant can sit next to the counsel who is arguing.
On the lighter side, apropos Mr. Shah's request, there should be a clock on the back. But for some of us, we need a calendar on the back.
Including the learned SG.
Time.
Including the learned SG.
Yes, sir.
We're not
I
being
said
sure.
sir, for some of us.
How long we have been arguing?
Yes, Mr. Shah.
One clock would be there. That's all I'm talking about. So may I begin, my lords? Yesterday I simply stated few things, which was by way of an introduction. I said that
I realized that I didn't say it. I realized why there's a crowd there.
I used to sit for seniors council as well. Yesterday I submitted that after the independence of this country, the native states all became free. They became sovereign unto themselves. I also submitted that in the matter of accession to the dominion of India, they all entered into various kinds of agreements, which were, as law declared by this court, is an act of state between the two independent entities, the dominion of India on the one side and the native states on the other side. I also submitted that the relationship between these native states and the dominion of India was determined by the documents which were executed. In the case of state of Jammu and Kashmir, I also submitted that it was only instrument of accession which was executed between two entities, the dominion of India and the state of Jammu and Kashmir. Making that as the base, that would be the relationship between the dominion of India and this entity. Subsequent to this, when the residuary sovereignty vested in the king, further documents were to be executed relating to this particular state. The Maharaja issues the proclamation of 1948. In that proclamation, he says that we need to have a national assembly to frame a constitution. This is the genesis. The genesis of framing of the constitution of Jammu and Kashmir is rooted in the nature of instrument of accession as well as the proclamation of 1948. That's where we arrive at the source as to why second constitution for the state. Then the third thing is that after these declarations are made and no further documents are executed, but at the same time the Constitution of India was being made. So the problem and the issue, the question before them was what is to be done. This is what I said yesterday. And I also submitted that meanwhile, some more developments had taken place, which had an external dimension, which also shaped and influenced the Constitution Assembly of the Union of India. Now, this is the whole scenario which existed before Article 370 was adopted. And I also submitted that the residual power came to be subsumed by Article 370. My lord's observation was what happened to instrument of accession. But subsequently, when you agree to a constitution, you had acceded to the dominion of India, maybe partly only, may not be fully, you had not integrated, I would say, because you had not executed merger agreement. So the Article 370 subsumed this remaining power. Whether we call it sovereign power, residuary power, but it retained the power with itself. And therefore, next question would be the exercise of this power. Whereas the power is there in terms of the instrument of accession. Now in Article 370, how it was to be exercised. I will make a digression here. Perhaps at that point of time, it was felt that since we don't have a Maharaja any longer, we don't have any other authority to do it, who would go in almost like a substitute for merger agreement? If complete integration had to take place, how could this be brought about? A mechanism is evolved in 370 that will be entirely for the people of Jammu and Kashmir to integrate with India. Whereas they have done it with accession, they have acceded to Union of India, but to integrate it completely, as I said, shaking hands and embracing, the embracement was left to the people of Jammu and Kashmir, but in accordance with the mechanism and the procedure prescribed by Article 370. What kind of power the Maharaja has retained? Most important was the power to make laws, which I said yesterday. Therefore, Article 370 itself says all of the provisions of the constitutions are excluded. Notwithstanding, all provisions are excluded except Article 1 itself and Article 370. Everything else is excluded. Nothing else applies to the state of Jammu and Kashmir. The first part, as I come to that, I'm just developing this point for lots of consideration. The first part of Article 370 talks of application of laws. In list 1, could be list 2, list 3, it talks of application of laws. Now that application of laws, subject to one condition, that since I had donated some power earlier under instrument of accession on 26th of October, like defense, communication, foreign affairs, so there was no further donation required. Therefore, the word consultation was mentioned. Simply consult. Consult does not mean agreeing. You just have to talk to somebody in normal language also. The consultation, you talk to somebody whether he agrees or disagrees, but the dominant person would go in his own way after talking to him. But if for application of it, the word concurrence was required. Now, there's a fundamental difference in consultation and concurrence, where both have to be ad idem, both have to agree.